Today we are proud and honored to have two speakers and to have spent their time to come and give us an inside look into the world of Islamic financing. Without further ado, I would like to invite our honored guest speakers here today. Firstly, we have Mr. Tom Reynolds. Mr. Tom Reynolds is a seasoned partner of 12 years at Rose and Hamlins. Our second speaker today is Mr. Elias Mubarak. Mr. Elias Mubarak is finished his law degree at the London School of Economics and Political Science, and also has a master's in law from the University of Manchester. He is also a partner from Rose and Hamlins. So without further ado, I'd like to invite the first speaker. Our first speaker for today, which will be Mr. Tom Reynolds. And Mr. Tom, the floor is yours.
Thank you, Ibrahim, and good afternoon, everyone. I can't promise I'll do as professional an introduction to Trowers as Ibrahim has done to the presentation as a whole, so thank you for that. I can only assume you didn't mention my academic credentials because they're not as impressive as Elias's, but maybe I didn't tell you them. Maybe I didn't tell you. I'm teasing you. I probably didn't tell you them, so forgive me for that, and that's purely a joke. But no, it's really great to be here today, and thank you all for joining us on this presentation. I'm not going to say a great deal because Islamic finance and Sukuk are not my area of expertise, but they are very much Elias's area of expertise. I'll allow Elias to give a brief introduction to himself as well as Yuan Ping. My name's Tom Reynolds. I'm one of the three partners at Trowers and Hamlins in our office in Kuala Lumpur. We've got certainly by the new year, we'll have 21 staff overall. So we've grown considerably from 4 people 6 years ago to numbering 21. And we're an international law firm. We were the first to gain a license in Malaysia in 2015 when the market was partially liberated. And part of the reason it was liberated was so that we could bring our international Islamic finance expertise to Malaysia. And help grow the Islamic finance market here, with Malaysia being one of the main Islamic finance hubs. And that's what we've continued to do, largely, like I say, through Elias and his team. I personally am a corporate commercial lawyer, so I work on things like mergers and acquisitions, joint ventures, commercial contracts. If you've ever had to tick a consent box on a data privacy notice on a website, I'm one of the unlucky lawyers who gets to draft things like that occasionally for clients who are making sure they're compliant with data protection laws. So I get involved in a real mixture of things, but luckily for me, nothing as complicated as Islamic finance and Sukuk. So Malaysia is our hub in the Far East. We've also got offices in the Middle East where we've been for many decades, and that's where a lot of our Islamic finance expertise stem from, as well as 4 offices in the UK. So that's a brief introduction to the firm and me. Yuan Ping, do you want to say a couple of words, well, more than a couple of words, but a bit of a hello and a bit of background?
Yeah, sure. Thank you, Tom, and hello, everyone. So before we hand over to Elias to go into the substantial aspect of this session, Tom and Elias have asked that I give a brief introduction of myself. So very briefly, I graduated from UKN some years ago. I'm batch 26. So enough number of years that our syllabus is probably a little bit different, not entirely different, but I still remember the lecturers, the layout of our faculty, and of course, my student ID, because we write it again and again and again. Now, I've been with Trowers for 3 years now. I am part of the international team based out of Kuala Lumpur, the 21 group of people, the 21 people that Tom mentioned earlier. So as you can see from the slide that's in front of you, the firm has significant history and presence in the Middle East. And of course, since joining, I've been very fortunate to be involved in a number of deals, transaction, and also arbitration based out of the Middle East. And as you would guess, anything to do with the Middle East will involve some aspect of familiarity or at least awareness of Islamic or Sharia compliance, at least with some principles and coincidentally, we learned some of these principles in law school. So I'm very fortunate to be able to tap into some of that knowledge that's somewhere in my brain. But of course, as everyone here would be able to understand, knowing the principles and applying them is completely different. And I think we have a very good opportunity here for Elias to be able to show you how the principles that we learned from school is now applied in real life, in a real transaction, when he goes through the case studies. So without further ado, over to Elias.
Thank you so much, Shrimping. That was a very kind introduction. I hope I can live up to that billing. As some of you may have joined us in our previous session where we went through some of the basic principles underpinning Islamic finance and particularly structuring transactions. But I understand that there's a few of you who have joined us today who may not have had the chance to join the previous session. So for your benefit, as well as the benefit of those who did attend the previous session, as it's been a while, I'll do a quick recap of what we covered in the last session, and then move on to a couple of new structures and themes that I wanted to discuss today. Can you still see the slides?
Yeah, absolutely.
My apologies, I've been having some issues with my screen share, which I'm told is a function of my age. But
They're on the intro slide at the moment, Elias. I don't know if that helps.
That does help. Thank you, Tom. So before I delve into it, I'll give you a brief background in terms of my experience in the Islamic finance world. I've been working in Islamic finance for over a decade now, in one form or another. I've worked across a range of different sectors, including regular banking and finance transactions in the Sharia compliance space, as well as working on a number of capital markets transactions, both at Trowers, where I've been for about over 8 years now, as well as previous firms that I've worked with. So, as Wenping said, there are a number of Islamic finance principles that underpin the structuring of Sukuk transactions, generally speaking, how they're applied in practice, and some of the issues that come up in cross-border transactions or cross-border Sukuk issuances can vary greatly from what we would have studied on a more theoretical basis. I remember studying Islamic finance before being, in my spare time, before being involved in or on transactions, and I have to say the first 2 or 3 transactions I worked on were a steep learning curve for me. Right, so we covered briefly what Islamic finance is in our previous session, and the short summary would be that Islamic finance, as practiced today, involves the application of Sharia principles to financial activity. We touched on the key prohibitions, and as most of you, obviously, or all of you would know, one of the key prohibitions is the prohibition on riba. So that's the best known, biggest practical difference between Islamic finance and conventional banking. As you will all know, riba is a prohibition of interest on money, and the underlying concept is that money has no intrinsic value. There's a measure of value, and there should be no charge for its use. So these prohibitions on, among other things, riba, doesn't mean that there is no Islamic finance or Islamic, Sharia compliant debt financing. What it does mean, however, is that you would need to employ certain Sharia compliant structures in order to effect the particular transaction that the parties wish to enter into. And some of those common structuring principles are listed on that slide. We went through them very briefly in our last session. And as we'll come to see from our recap, we did talk in some detail about the Ijara structure and the Mudaraba structure. And I will recap those case studies shortly. Before I do, I'll just quickly recap what a Sukuk is. And according to AOFI, which I've quoted there, Sukuk is a certificate or are certificates of equal value representing undivided shares in the ownership of tangible assets, usufructs and services, or in the ownership of the assets of particular projects or special investment activity. In reality, what Sukuk certificates actually are and what they're commonly viewed are in the markets as is an alternative to corporate bonds. So they're often called Islamic or Sharia compliant bonds. And the underlying principle, the underlying intention is to put an investor in the same position as the holder of a corporate bond, the same legal and commercial position as the holder of a corporate bond, but to achieve that in a Sharia compliant manner. Now, this is typically achieved by the purchase of income generating assets by a special purpose vehicle, which I'll refer to throughout this presentation as an SPV, who holds the assets and the income provided by them on trust for investors. So the Sukuk certificates represent a beneficial entitlement to certain assets and income. These numbers are probably slightly outdated now. I haven't had the chance to update them. I presented them at the last session in April, and they give you an idea about the size of the global Sukuk issuance or the global Sukuk market, both in terms of absolute numbers as well as a proportion of the Islamic finance sector generally. As you can see from the second graph on the right, the Sukuk, the volume of Sukuk assets or Sukuk issuances is in yellow, and that does form a significant chunk of the Islamic finance market, although banking assets, as you will see, comprise the bulk of the Islamic finance, bulk of assets in the Islamic finance segment. The case studies that we discussed in detail are the Danagas Sukuk issuance and the Nakhil Sukuk issuance, and I'll recap those in a moment, and then move on to talk a bit about the Golden Belt Sukuk issuance, as well as discuss one of the Etisalat Sukuk issuances, and then close with a brief overview of Green Sukuk. The overview of Green Sukuk wouldn't be a case study per se, but more of a description or overview as to what they are and how they can be used, and why we see great potential in that segment going forward, especially for raising funds in relation to building sustainable projects, which I think we all sort of see now is probably desperately needed. By the way, as I go through the presentation, if you have any questions, please feel free to pop them into the chat function, and I'll try and address them at an appropriate time, or if not, I'll turn to them when it's time for Q&A later. So, but please do pop them into the chat function. Again, I'm having some slight difficulties with my Zoom application today, so hopefully I can see them when you pop them in. If I don't, then again, I'll turn to them at the Q&A segment.
I'll keep an eye on it for you, Elias. Don't worry.
Thanks, Tom.
Man. No worries.
Thanks, Tom. So just appreciate that. All right, so let's turn back to the Danagas Sukuk. Now, the Danagas Sukuk structure is put up on the screen there, and we discussed that in some detail on the the last session, so I won't go into it in too much detail. But suffice to say that effectively the Danagas Sukuk structure that we're discussing at the moment employed what's referred to as the Mudaraba structure. So effectively Danagas, which is a UAE incorporated petrochemical conglomerate, wished to raise money in the capital markets in a Sharia compliant manner, but it didn't have particular assets that it wanted to use in the context of this particular Sukuk issuance. So the structure employed was that an SPV was set up, which you can see on your screen there in the blue, one of the blue squares is Danagas Sukuk Limited, which would act as issuer and trustee. Danagas Sukuk Limited issued certificates into the capital markets and collected the proceeds of that issuance from certificate holders or investors, and then appointed Danagas, the UAE conglomerate, as a mudarrib to manage the investment of those funds and to effectively invest those funds in income-generating assets that would realize sufficient income or returns to allow Danagas to make payments due to certificate holders under the Sukuk certificates. upon an event of default or upon the maturity of the certificates, Dana Gas Sukuk Limited, i.e. the SPV issuer, would sell those assets to Dana Gas in its capacity as principal, rather than in its capacity as mudarrib. And the relevant purchase price for those assets would be effectively amounts outstanding under the certificates. And the SPV would use those funds to make payments to the certificate holders. That's a very brief summary of that structure. Again, if there are any questions that you may have on that structure, please do pop them into the chat box function. Now, what happened with this Sukuk? Dana Gas faced some financial difficulties, and then it sought to avoid its payment obligations under the transaction documents by claiming that the transactions and the transaction documents were no longer Sharia compliant. It brought this argument before the English courts, and the English courts rejected this argument on the basis of a number of reasons. One of the positions that the English courts took was that Dana Gas had represented under the Sukuk documents that it was comfortable that the Sukuk documents were Sharia compliant, and it undertook not to raise any objections as to matters of Sharia compliance in the future. So on the basis of that, among other things, the English court rejected the argument made by Dana Gas that it shouldn't make any payments on the Sukuk certificates because they were not Sharia compliant. Now, Dana Gas then brought, or simultaneously, or in parallel, Dana Gas also brought an action before the UAE courts. Now, the position in the UAE courts is more complicated than it was in the English courts because, among other things, the UAE incorporates elements of Sharia into its laws, and Sharia forms a source of jurisprudence effectively in the UAE, and has made its elements of Sharia compliance makes its way into a number of UAE laws. Before the UAE courts could decide on this issue, however, Dana Gas did reach a settlement with the relevant creditors. The Sukuk was restructured, and I think actually has now been redeemed, if not in part, if not in full, certainly in part. So I'll move on to the summary of the Nakheel structure. This structure employed what we call the Ijara structure, which effectively employed the concepts of sale and leaseback. Nakheel, various Nakheel entities, which you can see they're being referred to as Nakheel Holding 1, 2, 3, and Nakheel PGSC, wanted to raise funds in the capital markets for the purposes of funding the construction of real estate assets in the UAE. So Nakheel was the developer, or is the developer, that's responsible for a number of major projects in the UAE, including the Dubai Palm. You can see a small picture of that on that slide. I'm not sure if it's very visible on your screens, but it's a Dubai Palm, fairly high profile landmark, and Nakheel was looking to raise funds, generally speaking, to develop a number of such projects. Nakheel, obviously, as you would imagine, as a developer, had a number of real estate assets that it could use for the purposes of structuring the Sukuk. And what it did use were a number of real estate assets, which it, on paper, transferred to a special purpose vehicle set up as Nakheel SPV. Nakheel SPV paid the purchase price for those assets by issuing Sukuk into the capital markets and receiving the subscription funds for those Sukuk from the various Sukuk holders. It paid those funds on to Nakheel, and then it leased the assets it had purchased on paper from Nakheel. It leased them back to Nakheel for rental amounts, which it would then use to pay amounts due to the Sukuk holders under the Sukuk certificates. Now, as you would have all probably be aware, in around sort of late 2009, the financial world was in turmoil, and Dubai World had sustained a number of heavy losses. And then Dubai World, which is the ultimate owner of Nakheel Holding, requested a restructuring of about $26 billion in debts including the restructuring of the Nakheel Sukuk. There were a number of legal issues that we touched upon in the context of that restructuring, which I won't delve into in great detail today. But those issues arose from certain deficiencies, potentially. Maybe deficiencies isn't the right word, but certain gaps, perhaps, in UAE law that meant that the Sukuk holders were not in as strong a position as they thought they were. That, along with a combination of other factors, brought about the restructuring of that Sukuk, because Sukuk holders effectively took the view that should they enforce or should they seek to enforce their rights under the Sukuk certificates and the various transaction documents, they may not be successful for a number of reasons. One of those reasons was that the Sukuk holders had thought that Nakheel SPV actually owned the relevant assets that were transferred to it. So they had thought that potentially they could enforce by way of asking the SPV or requesting the SPV to sell the relevant assets. But actually, in reality, the transfer of the assets to the Nakheel SPV was not effective under UAE law because it had never been because that transfer had never been registered with the relevant land registry, and therefore the transfer was simply a contractual transfer, and there were no rights in REM that were effectively obtained or attained by the issuing SPV. So that's a brief. I think that's a brief overview of where we got to on the last session. Again, if there are any questions or if there are any points that you'd like me to cover again, please do pop them into the chat. Right. So I'll move on to the Golden Belt Sukuk. Now, the Golden Belt Sukuk employed a very similar structure to the Nakheel structure. So I won't go into the details of that structure because be covering old ground, so to speak. What I will go into is the reason I put it up as a case study is because it did highlight some interesting aspects of English law in the context of duty of care. And I thought it might be interesting from our perspective to go through some of those points. Oops, sorry. My apologies. My slides seem to have developed a life of their own.
Is that a teaser of the structure in case anyone thought the structures were going to get easier as the presentation went on?
Yes, indeed. I'm trying to dissuade people from that view. My apologies. Sorry about that. Are we back on screen now?
Yeah, it's back as it was.
Okay.
And
definitely been having some issues with my Zoom app.
Golden Belt. Yeah, that's the one.
Yeah, there we go. All right. As I mentioned, there are a number of interesting English law issues that were explored in the context of this case. Before I get into those, I'll give you a brief background as to what led to the relevant legal action. So in about mid 2007, $650 million Sukuk was issued by a Bahraini SPV called Golden Belt One Sukuk Company to raise capital for a Saudi Arabian conglomerate called Saad Trading and Contracting Financial Services, which I'll just call Saad for short. The Sukuk was effected by a suite of transaction documents, most of which were governed by English law. One document that was not governed by English law was a Saudi law-governed promissory note that was in the sum of $650 million, the principal amount of the Sukuk issuance. And that was issued by Saad in favor of Golden Belt in support of Saad's obligations under the Sukuk. The promissory note was signed by an individual called Man Al-Sana, who is the principal shareholder of Saad Group, or the principal of Saad Group. The reason behind obtaining this promissory note was that there are certain issues with enforcing English law judgments in Saudi courts, and Saudi Arabia being the jurisdiction where most of the assets of the Sada group, of the Saad group rather, were held at the time, it would, effectively creditors would have to enforce in Saudi Arabia to have access to those assets to recover amounts owed to them. It was felt that it was too difficult and there were complications with enforcing either a Saudi law contract in Saudi Arabia or enforcing an English law judgment in Saudi Arabia. So to enhance to enhance the creditor's position, a promissory note was sought from the Saad group, and a promissory note is deemed to be enforceable on demand in Saudi Arabia. So that was seen to be a significantly better position than seeking to enforce contractual rights in the Saudi court. So a default occurred under the Sukuk amid allegations of fraud and embezzlement surrounding the Saad group. We were actually involved in a number of related matters that surrounded that, which I won't go into today because that's sort of an entire presentation, if not a movie in its own right. But we were involved in sort of some of the other matters surrounding the collapse of the Saad group. Now, due to the uncertainty in enforcing the so then creditors effectively, creditors sought to offload their debt at that point in time to purchases in the secondary market, and a number of debt funds purchased the Sukuk certificates issued by the Golden Belt SPV. Those funds are those debt funds are known for being very aggressive, and they tend to have no relationship with the relevant parties, and so they don't hesitate in taking very aggressive legal action against the relevant debtors to recover as much as possible. And they tend to buy the debt very cheap and then seek to recover a certain number of cents on the dollar effectively and make a profit that way. But the principal reason that these debt funds purchased that debt, despite the fact that the Sukuk was in default, was because of the existence of that promissory note. So they saw that as putting them in a significantly better position, and they took the view that they would be able to enforce that promissory note and recover significant amounts of money or significant amounts of the debt outstanding and owing to them. Now, when they sought to enforce this promissory note, the Saudi courts, it was deemed to be unenforceable in Saudi Arabia because it was deemed that the signature on that promissory note was not a wet ink signature. Experts sort of concluded that it was a laser printed signature rather than a wet ink signature. And under Saudi law, the promissory note had to be physically signed in wet ink, using wet ink effectively for it to be effective. So the promissory note was deemed to be unenforceable in Saudi Arabia. And so Golden Belt SPV, on behalf of a number of creditors, as well as those funds as a joint claimant or as joint claimants, brought an action against the arrangers of the Sukuk, being BNB Paribas, for negligence, effectively. Now, the main issue before the English courts was whether BNP owed, as the arranger of the Sukuk transaction, owed a duty of care to Golden Belt and to the creditors, in particular the funds, to ensure that the transaction documents were properly executed. Now, the test before the English courts in establishing a duty of care is threefold, and it was discussed at length in the court judgment. I'll read off my notes here in this instance. So the first limb of that test is whether the loss to the claimants was a foreseeable consequence of what the defendant did or failed to do, whether there was sufficient proximity between the parties, and whether in all circumstances it is fair, just, and reasonable to impose a duty of care on the defendant to the claimant. So on the first limb, the judge concluded that the loss to the funds as Sukuk holders was a reasonably foreseeable consequence of BNP failing to ensure that the promissory note was properly executed. So, the judge took what appears to be a fairly sensible view that if BNP failed to ensure that the promissory note was executed properly, the Sukuk holders would suffer a loss because it's likely they would suffer a loss in an enforcement scenario because they wouldn't be able to rely on that promissory note. Now, on the second limb regarding proximity, it was held that there was sufficient proximity between BNP and the investors. One of the reasons for this was that BNP was prominently described and marketed even as the arranger of the Sukuk certificates on all of the disclosure documents relating to that Sukuk, to those Sukuk certificates. So by marketing itself as the arranger, the judge held that what BNP was effectively doing was giving the Sukuk holders reassurance that it as arranger would arrange or would take actions to ensure that the transaction documents were properly executed. And BNP knew that investors would rely on them taking steps to ensure that the transaction documents were properly executed. And in fact, there was no one else on which the Sukuk holders could rely on to carry out this important function. Now, on the final limb, as to whether it's fair, just, and reasonable to impose a duty of care on BNP, the judge found that imposing such a duty of care on an arranger to ensure the proper execution of the transaction documents would not require the arranging bank to take any action that it should be taking already. So it wouldn't be imposing a more onerous standard on arrangers in Sukuk transactions. It would not be imposing an additional obligation on arrangers other than something that they should actually already be doing. So that limb was deemed to be satisfied as well. And drawing all those threads together, the judge concluded that BNP, in quotes, dropped the ball, his words, not mine, and had failed to live up to the standard, and I'll quote here from my notes again, in fact, from the judgment, failed to live up to the standard of the ordinary skilled banker engaged in a transaction of this nature. And therefore, they owe their duty of care to the purchasers of the Sukuk, both in the primary and secondary markets. This case is important for a number of reasons, and in particular, because this is the first time that the English courts have found that a bank that has acted as an arranger to a publicly listed capital markets issuer, in relation to a publicly issued series of Sukuk certificates, owes a duty of care to purchasers of that debt in the secondary market. Obviously, creditors in the Sukuk markets or holders of Sukuk certificates saw this decision as a very welcome decision, and this decision was generally seen by market commentators as being one of the reasons why English law is or should often be chosen as the governing law of Sukuk documents, particularly where investors are located across a number of different jurisdictions. And again, the reason being that the market perceives the English courts as taking predictable decision based on precedents and generally following or taking decisions that the market expects them to take. And in contrast with a number of jurisdictions, for example, some of the GCC jurisdictions that we've touched upon this session and as well as last session. So the choice of governing law when it comes to structuring and documenting Sukuk issuances is very important. And in fact, we would consider subjecting all of the Sukuk documents, not just some of them, to the laws of jurisdictions that allow greater certainty as to enforcement, be they the United Kingdom, Malaysia, Singapore, established jurisdictions with a strong system of precedent. For example, the UAE courts are not bound by precedent, so they may take decisions based on one set of facts today, and then based on the same set of facts tomorrow, they may take a different view, which creates a degree of uncertainty that commercial parties are generally tend to be averse to. Right, so I think we can now move on to the next structure that I wanted to discuss, which is the Sukuk al-Manfa structure. And we'll use the case study of an Etisalat Sukuk issuance that utilized this structure. The structure looks slightly complicated when you look at it at first glance or for the first time. And we'll talk through it, and you'll see that it's actually a relatively simple structure, but fairly innovative, particularly when it was first used coming up to about 10 years ago now on Sukuk issuances. As you would have gathered from the Sukuk structures that we've discussed so far, Sukuk issuances and I guess Islamic finance transactions in general require the use of an underlying asset to structure transactions, and in particular to give rise to debt obligations in a Sharia compliant manner. Now, what if you have an issuer or an obligor that wishes to issue Sukuk, but doesn't have the requisite amount of requisite level of assets or requisite level of unencumbered assets, but it has significant value tied up in certain things like a license to operate communications networks in a particular jurisdiction. So in that context, what a number of very clever bankers and lawyers did was to utilize the principle of manfa in structuring Sukuk transactions. Now, in the manfa structure, the underlying asset is the capacity or rights of commercial activities, allowing for the use of intangible assets. And the nature of those rights or what those assets are will depend on the particular obligor. So in this particular instance, or this particular case study, we're looking at the example of Etisalat, which is a mobile communications operator that has significant operations in the UAE, as well as through various subsidiaries, a number of GCC and I think Southeast Asian economies as well. The underlying asset in this particular Sharia structure was the right to use the telecommunications networks being operated by Etisalat. So Etisalat, through the lease of certain communication structures, infrastructure, as well as through communications licenses, telecommunications licenses it had obtained in certain jurisdictions, in this particular case, the UAE, had the right to use certain telecommunications infrastructure. Now, because of the way that those lease agreements were structured and the way that those telecommunications licenses were drafted, it was not possible for Etisalat to actually use the underlying telecommunications infrastructure itself as the subject of a Sukuk transaction, but what it could use was the right to use the infrastructure, the right to use airtime, or the right to airtime. So the way the structure worked was that Etisalat, as the seller of airtime vouchers, would sell airtime vouchers to an issuer SPV established for the purposes of the Sukuk transaction. Those airtime vouchers represented the right to use the telecommunications networks as leased by Etisalat and as permitted by the by its telecommunications license. So that's point 3. The arrow that's labeled 3 on the left-hand side of that diagram. So the sale of those airtime vouchers to the issuer SPV was effected under a sale agreement, and the purchase price for those airtime vouchers was paid by the issuer SPV using cash proceeds of the issuance of Sukuk certificates into the capital markets. So points 1 and 2 on arrows 1 and 2 to the bottom left of that diagram. Now, the issuer SPV then appointed Etisalat as distributor under a distributorship agreement. And under that particular distributorship agreement, Etisalat agreed that it would undertake the sale of those airtime vouchers to its customers in return for a minimum price. The minimum price it was supposed to attain for the sale of those airtime vouchers was the cost price of those vouchers, i.e. principal amounts raised, and a profit amount. That profit amount would equal amounts due to be paid by the issuer SPV to investors under the Sukuk certificates. So the appointment of the Etisalat as distributor is the arrow in the middle there, labeled 5. And then as you can see by 6 and 7, Etisalat is obliged to sell those vouchers to its customers and then collect sales revenue from that sale. In effect, what that meant was Etisalat would effectively apportion would in principle be apportioning a amount of its fees generated from the sale of mobile airtime plans or sale of data plans, for example, to meeting its obligations under the Sukuk structure. So those revenues would be collected and put into collection accounts, which is 7B, the checkered arrow towards the top right. And then excess sale revenues, so if it managed to sell more than it had agreed to, excess sale revenues would go into a reserve account. And amounts that were sitting to the credit of that reserve account could be retained by Etisalat as an incentive fee. But in the event of a shortfall so to the extent that Etisalat was unable to actually sell sufficient airtime vouchers, amounts sitting to the credit of the reserve account would be applied towards meeting that shortfall. In terms of dealing with a shortfall in revenues generated by Etisalat as distributor of airtime vouchers, there was another mechanism that was employed to protect the legal position of the certificate holders. That mechanism was effectively an undertaking by Etisalat as a principal, acting in its principal capacity, to purchase any excess airtime vouchers not sold by Etisalat as the distributor, for an amount equal to the minimum purchase price of those airtime vouchers. And you can see that particular mechanism illustrated at point 12 and 13 of the on the far right of your screen. Now, the amounts that were collected as a result of the sale of these airtime vouchers, or amounts that were generated through the sale of the airtime vouchers to Etisalat under that purchase undertaking, would be paid to the issuer SPV, and the issuer SPV would use those amounts to make periodic distributions due to investors under the Sukuk certificates. So every 3 to 6 months, amounts would be due under the certificates to investors, and the issuer would use the profits generated by the sale of those airtime vouchers to meet its payment obligations under the Sukuk certificates to the investors. Now, at the end of the tenor of the Sukuk, so on the particular scheduled maturity date, or if there was an event of default, Etisalat had also undertaken to purchase airtime vouchers for an amount that would effectively be calculated as amounts due to the investors under the Sukuk certificates. And Etisalat would be under an obligation to pay that amount to the issuer SPV, and then the issuer SPV would use those amounts to pay investors what they were owed under the Sukuk certificates. And that falls under that 12 and 13, under those points 12 and 13 that you can see on the far right of your screen. So that's an overview of the Sukuk al-Manfa'a structure, which marked a very innovative development in the Islamic finance, and in particular the Sukuk markets, and was used, in a number of different industries, from as you can see from the telecommunications industries as well as the airline industry. So Emirates and Pakistan Airlines have issued Sukuk based on this structure, as well as in the petrochemical industries, in relation to certain petrochemical, in relation to rights to develop certain petrochemical assets. I think that's all I want to say about the Sukuk al-Manfa structure today. I hope that was clear. I went through the structure fairly quickly. So to the extent, again, that something wasn't clear or you had any questions, please don't hesitate to pop them into the chat function.
Just jumping in briefly, Ed.
Right, so let's turn to green Sukuk.
Sorry, I was jumping in briefly, partly because you froze momentarily, so I thought I'd fill some of the void, but no questions at the moment. I think what I'd probably say is I've been a lawyer for about 12 years, and I find that quite complicated. So to all those aspiring as Islamic finance lawyers out there, this is kind of, I'm not saying it's as complicated as these things get, but this is a pretty developed structure that what you tend to find as you go through your career. I remember the very first time I did a piece of Islamic finance work, thinking, God, this is complicated, and there's a satisfaction from understanding it in the end. And then one day you build up to Elias's level when all of this is relatively straightforward as well. But that's kind of one of the quite interesting things about being a lawyer, I think. And I think when one's a student, you see the black letter of the law and the textbooks and wonder how it kind of plays out in reality. And as the type of lawyer that we are, which is kind of transactional lawyers, so helping people do these deals rather than the litigators, the people in court, the one they do TV shows about. So this will be the more glamorous ones. This is a lot of what we do. So yes, there's the law, and knowing the law and interpreting the law correctly, as you've seen from some of these examples, is really important. But we also spend a lot of time doing structuring of transactions to make sure the money flows properly through the structure and that the documentation reflects all of that. And that's kind of another really interesting part of the Islamic finance world that is manifested here. Yeah. So it's just a few thoughts from me as I was listening.
I have a question.
Yes, Ibrahim, please.
I would like to, just for clarification, I would like to know whether the majority of Sukuk instruments existing in the market are Sharia compliant. Are they all Sharia compliant, or are a few of them non-Sharia compliant? The ones that are pre-existing in the market right now?
Well, it depends on who you speak to. So I think and this is actually one of the issues in the Islamic finance world, is that different market segments or different jurisdictions have different interpretations of Sharia law, as well as what is permissible and what is not permissible. For example, the view that Sharia scholars take in Saudi Arabia is probably considered to be a bit more strict or less flexible, less commercial, and they might consider a number of Sukuk transactions, including the one we've just discussed, not being particularly Sharia compliant. The view taken in other jurisdictions, for example, the UAE, Malaysia, Indonesia, is probably more commercial and flexible. And the view taken is that, yes, it's not perfect, but on the balance of things, it's Sharia compliant enough, and so can be accepted for the purposes of investing in the Islamic finance segment. The view that most scholars will say is that, yes, it's not perfect. Ideally, we will want to move towards a more perfect structure, Sharia compliant structure, but we need to start somewhere and then evolve the industry to make it more Sharia compliant. As to whether or not that actually happens is a matter for discussion. And some people, including a number of Sharia scholars that I speak to on a regular basis, are now becoming slightly disillusioned with the view that things might evolve into a more Sharia compliant, might evolve towards a more Sharia compliant status. Does that answer your question, right?
Yes, it does actually. Thank you.
Sure. Thanks for the question. Keep the questions coming, please. It's far more fun when it's an interactive or a bit more interactive, and I can sort of address any questions that you might have. discuss any sort of burning issues that may be plaguing you at night. All right, so I think we can move on to green bonds. Let me try and. Right, so very simple slide there. Because this isn't a case study per se, but more of a discussion around what, generally speaking, what green bonds are and how why they're becoming a very popular form of investment mode in Islamic finance. Now, obviously, as you will all be keenly aware, countries around the world are struggling to deal with devastating damage caused by extreme climate change related weather events. According to the UN Environment Programme, the cost of adapting to climate change in developing countries alone will rise to between $280 billion and $500 billion per year by 2050. And that's likely to be a conservative estimate. So in order to, there's a huge amount of financing that's needed in order to mitigate the costs of climate change, and in particular to mitigate the impact on people and societies. So the question is, how do we finance that? And this is where green Sukuk come in as a very natural fit. So what are green Sukuk? I can hear some of you, potentially none of you, asking. A green Sukuk can be seen as a Sharia-compliant instrument issued into the capital markets, the proceeds of which are used to fund investments in renewable energy or environmental assets such as solar parks, biogas plants, solar energy projects, and other infrastructure projects focused on environmental sustainability. So in reality, there's no real difference between a Sukuk, a regular Sukuk, and a green Sukuk, other than the fact that in the context of a green Sukuk, the proceeds are being used for a particular objective, and that objective being the development or funding of projects that are considered to be environmentally friendly or that will have some kind of positive environmental impact in the future. Now, in July 2017, the world's first green Sukuk was issued in Malaysia, as some of you would know, and it was used. The proceeds of that Sukuk was used to fund a large-scale solar energy project in Malaysia. This was shortly followed in 2019 by a green Sukuk issued by the government of Indonesia, and this was a very encouraging start. But given the amount of funding required in this particular space, there's clearly a lot of room to grow. Now, the emergence of green Sukuk, I think, has been seen by market participants as a natural evolution in Islamic financing. So Islamic financing, as we've discussed to some extent, by its very nature, is based on ethical principles and incorporates many elements of environmental and social responsibility, effectively. And the rise of the popularity for green Sukuk, I think, synchronizes with the growth globally by a number of investors in a number of segments and a number of jurisdictions for investment in sustainable, sustainable projects and sustainable or instruments linked to ESG. There's a huge amount of appetite for instruments that can be seen to be effectively green or ESG friendly, or that meet certain ESG criteria. And there just aren't enough issuances out there to meet that demand. Now, why are there not enough issuances out there to meet that demand? And I think that brings us to discussion of some of the challenges that the green Sukuk industry or segment is facing at this point in time. I'll touch on a few of those. I think the first one that's commonly cited, particularly by lawyers, is that there's a lack of sort of explicit and shared objectives in the green Sukuk market, and this can be a potential source of misunderstanding. So there's no general definition or universally accepted definition of what a green Sukuk is. the definition of green financing is generally fluid, and each jurisdiction refines it by way of regulation and self-governance. And our green bonds and green financing, green Sukuk, have historically constituted of a number of market-driven and regulatory regimes. So in Malaysia, Malaysia benefits from a fairly strong sustainable finance ecosystem, and there's a number of guidelines which are very helpful. So these include the Sustainable and Responsible Investment Sukuk Framework, issued in 2016, the ASEAN Green Bond Standards, and the ASEAN Social Bond Standards. However, those standards aren't universally accepted and applied, and some people argue as to just how green should a project be in order for it to meet certain criteria. So certain investors in, or certain investors in the European markets, for example, may wish to see a certain set of criteria, whereas investors in China may, for example, wish to see another set of criteria. So this creates fragmentation in that sector, which results in lack of standardization, higher transaction costs, and smaller investor pools for each particular issuance, which means that the pricing of that issuance isn't as low as it could be, which further inhibits issuances. So the lack of standardization and harmonization in the green Sukuk markets is a particular issue at this point in time. But as further regulatory changes occur, and as a number of countries, a number of institutions sign up to global accords, we're hoping that that standardization occurs over time. Now, another issue with sort of differing standards in various markets is that it gives rise to what's called regulatory arbitrage. What effectively that means is that certain governance gaps can be exploited by firms or by issuers to engage in greenwashing. So effectively issuing a Sukuk in a particular jurisdiction that can be labeled as green, but actually that doesn't meet certain criteria in other jurisdictions. But because it's been labeled as green, a number of investors are effectively drawn to that particular issuance. And then they find out that actually it's not as green as they thought it was, which dents confidence in that particular market, which leads to a vicious spiral downwards. I've got here in my notes which is a bit more eloquently put, so this poses a threat to the stability and legitimacy of the green Sukuk market.
Elias, there's a question. I'm loving this. This is such a fascinating subject, and it cuts across so many areas. I mean, we released some articles earlier this week as a firm about the very subject of greenwashing and the regulatory impacts. But also, I think a lot of you, it might be something that sounds familiar in a consumer context. Whether it's Volkswagen saying their cars met certain emission standards, which they then worked around to make sure they hit them without incurring the costs of it. Whether it's consumer action. There was a court case earlier this year whereby Royal Dutch Shell, the big oil major, now have to have seen a 50% reduction in carbon emissions by 30, but someone can correct me, it's either 30 or 40. But also in the context of consumer products, we all go to the supermarket and get told this is an environmentally friendly item, or this was made with recycled plastics, and whether that's genuinely true. So this greenwashing issue is a sort of a legal or a litigation or a litigator's sort of minefield in its own that I think we're going to see a lot more of in so many different contexts. Sorry, I'm now just waffling on in some stuff I've read that's interesting, but it's kind of similar to that, I guess, what you're saying, but in an institutional investor context. The question that is better than my commentary just was is from one of the participants who said, may I ask, what is the difference between conventional Sukuk and green Sukuk? And I thought it was a good one because it kind of points to what you were saying about not misconceptions, but trying to define, what a green Sukuk really is.
Absolutely, thanks for that, Tom. That was very interesting detail as well. Appreciate that. Actually, we've also released a couple of podcasts this week and last week where I've spoken with head of Al Rajhi Bank, in Malaysia around ESG principles, and we touched upon, among a sort of wide range of topics, we touched upon the subject of greenwashing, and that's something that he mentioned as well as a particular issue. So you're in good company, Tom. Good company. As I said, great minds think alike. Turning to the question that was asked, the difference between a Sukuk and a green Sukuk is really just that the proceeds of a green Sukuk are used for a very specific purpose, and in particular, the development of a project or a building or a set of infrastructure assets that will have a positive environmental impact. So an example may be anything from the creation of a development of a solar park to a very eco-friendly building that uses very low energy or has very low energy consumption. That would, in some jurisdictions, be seen as meeting the criteria for a green asset, and therefore for using that asset for a green Sukuk. That answers the question. Let me know if not, and I'll come back to it. So we talked about regulatory arbitrage and greenwashing as being impediments to the development of the green Sukuk market. And as I said, what we are seeing is a number of regulators, in a number of jurisdictions coming out with a set of principles that are starting to align. So that's hugely encouraging, and I think that's going to be a significant factor as that continues. That's going to be a significant factor in removing that particular obstacle to the growth of the green Sukuk market. Now, another reason why there hasn't been that much green Sukuk that has been issued is actually that there is a lack of underlying assets and underlying projects that are that are being initiated that meet those criteria, whatever the criteria might be in that particular jurisdiction. Now, why are there not enough green projects being undertaken? And that is a very complex question. I think that is difficult to answer. I think it's difficult to answer generally, but probably in the little time that we do have left, will be quite hard to go through the various strands that make up the answer to that question. However, I think one of there are a number of issues in particular jurisdictions that inhibit projects generally taking off the ground. So a classic example would be a jurisdiction that doesn't have adequate procurement, legal framework that facilitates efficient and transparent procurement and bidding for particular projects. That can act as an inhibitor to certain projects taking off the ground, or certainly can act as a cost to those projects, which prevents investors from coming in, which then prevents those projects from taking off. And so addressing those legal issues, I think, would be a fundamental step forward in a number of jurisdictions to promoting the development of public-private partnerships for the implementation of these green projects. And there has been some promising developments in that regard in a number of jurisdictions. So, for example, India, I think, recently issued a PPP toolkit and certain guidance papers, PPP standing for public-private partnerships, which a number of these infrastructure projects are structured based on the principles of public-private partnerships. Indonesia recently amended its PPP laws and policies to streamline procurement and bidding processes. And there are a number of other developments in jurisdictions that seek to give international investors a degree of comfort as to the viability and, of course, the bankability of particular projects, including updates to the laws to allow for alternative dispute mechanisms, such as arbitration, which give investors a certain degree of comfort as to enforcement and their ability to enforce against certain project parties should there be a default in relation to that project. And as we saw in relation to the cases that we discussed earlier, certainty of enforcement or legal certainty is very important to investors in particularly international investors. So by building up the legal frameworks in those jurisdictions, those countries are creating a more positive framework that encourages investors to come in and invest, particularly into green projects.
Elias, we've got another question for you, if it's a good time.
Yeah.
In the meantime, you can all play count the number of puns on that slide. I think I've got at least 3. The question.
There were more. I took some off. I thought it was a bit overkill. So actually, that is me reducing the number of puns on the slide.
The question that's come in is, may I ask, this is interesting actually, topical. May I ask, what are the strategies or innovations used that can make green Sukuk continue to survive, especially during this pandemic situation?
Yeah, it's a good question, actually. To be honest, I actually think that there is a huge amount of demand in the capital markets for green Sukuk, not just from Sharia compliant investors or investors who have to invest in Sharia compliant manner, but from institutional investors in all segments, including the conventional banking segment, conventional pension funds as well. There's a number of reasons for that huge demand, and actually that's something that's covered in detail in the podcast that I've just shamelessly plugged again, which you can find on a number of platforms, including what's the Apple one, Tom? I don't have Apple phone, but the Apple iTunes. Is it
well,
iTunes?
Young Ping has kindly sent a link to our website version, which has the links, but I'm on Spotify at the moment. Not at the moment. I've got onto Spotify to find the name of our podcast. Not that I'm listening to music while you're talking. It's called the Trowers Podcast, and I think it's got that name on all your usual platforms. I think that's the word.
Yeah. So it can be found on Spotify, iTunes, whatever the streaming platform is for Apple, and LinkedIn as well. So you can sort of access it on those platforms. Maybe what I can do is send a link to that along with my slides after this presentation, and it can be forwarded to all the attendees. So on that podcast, Oz Ahmed, who's my guest speaker, who's the head of Al Rajhi Bank in Malaysia, was discussed in some detail why there is a huge amount of demand for green bonds among other such products or other such ESG products. And part of the reason for that is that a number of stakeholders in these institutions, be they pension funds, banks, so the shareholders in banks, as well as a number of institutional investors, the shareholders or stakeholders in those institutions that traditionally buy fixed income instruments are placing a great degree of pressure on those institutions to start to demonstrate their ESG credentials. And part of the manner in which they can demonstrate those ESG credentials is by showing how they have been investing in and purchasing these green bonds. But I think the issue that they're facing actually is that there just isn't enough of these green bonds out there. And part of the problem for that, or part of the reason for that, is because certain green projects just are not taking off. And there are a number of reasons behind that. And we touched briefly upon certain steps that certain jurisdictions in Asia and other geographies are taking to create a more positive environment that promotes the implementation of such projects. And that can be effectively implementing a better procurement framework that gives bidders a greater degree of transparency into how they bid for a project and how they win the project, effectively trying to eliminate corruption in the and bribery in the award of certain projects, which obviously, to the extent that a country doesn't have a transparent bidding process or procurement process, and Yuan Ping would be able to talk to this far better than I do because she does a lot of this work. To the extent the country doesn't have a transparent system that prevents bidders from coming in, because it takes a lot of time and effort and money to bid for these projects. And if you're not successful, or you're not sure what the criteria are for success, then you'll be prevented from bidding for it. And the lower the number of bidders for a project, the higher, the higher the inefficiencies and the fewer the projects that are implemented. This sort of basic bottom line. So creating a legal framework that encourages investors, in particular international investors, to come in and invest in green projects, I think is key to getting more of these projects off the ground. I think another thing that's key is for governments in all jurisdictions really to offer incentives for these projects. Now, those incentives can take a number of forms, in particular tax breaks or subsidies. So governments can refocus their policies when it comes to subsidies. So at the moment, a number of jurisdictions offer fuel subsidies or implement fuel subsidies, which are actually very expensive and reduce the true cost of those fuels. So there's less incentive to implement green projects because fuel is being subsidized. That has the dual effect of making the green project more expensive, i.e. the products or the energy being produced by the green project more expensive comparative to the public price of those fossil fuels. And it also has the effect of taking away funding that could have been provided by those governments to those projects in the form of either tax breaks or actual upfront subsidies. So implementing a change in government policy around those subsidies and moving away from subsidizing fossil fuels and rather using those funds to incentivize green projects and particularly green energy projects, I think would have a significant impact in stimulating the growth of these green projects. So I think there's a lot of things that can be done. A lot of governments are taking steps and jurisdictions are taking steps in the right direction. And it's really a matter of accelerating those developments.
There's another question, Elias. Sorry, if there's a follow-on from that, let's pop it in the box.
I think we're officially in the Q&A segment, so that's perfect.
Yeah, perfect. Excellent.
I think I'll try and stop sharing my screen.
The commercial dynamics are interesting. It's more complicated in the institutional investment world. But to give another example, we see it a lot in sort of private equity, not so much private equity, but a lot of the funds we do. And and there, a lot of the pressure, yes, there's the governmental pressure, but actually a lot of the pressure comes from people like us and maybe people much wealthier than certainly me. But, a lot of us will invest in the equivalent of, PNB unit trusts or similar around the world. And where they are, there's increasing pressure from, I say our generation, but I'm probably kidding myself. I think I'm from your generation, but maybe my generation and your generation, who are more interested in not necessarily seeing the massive return on their investment. One of the factors is the return on the money you invest. One of the factors is its benefit to the environment, and so people are less interested in putting money into oil and gas majors to generate a higher return if they can put it into renewable energy majors that still generate a return for them, but maybe not at the same level, but in a way that contributes more to the future of the environment, basically. But the very micro example is my wife at home has bought at the weekend for the first time some environmentally friendly recycled toilet paper that we found for the first time in the supermarket. And if I tell you that one of my colleagues has described the old brand of toilet paper we bought as Atas toilet paper, then you'll have a sense of perhaps how much this cost. But for us, that was kind of a, yes, it's more, but it's more for the environment as well, and so on. So it's one of those, but in an institutional context, it's driven by our generation, your generation. It's driven by the managers of this money who want to be seen to have these reputations as well. So we've all kind of got to do our own bit as well, I guess. Sorry, I'm now straying desperately from any sort of legal territory and more into social responsibility. So I'll move quickly on to the question, which is, may I know, does the private sector also support green Sukuk? So how does the private sector get involved in that?
Yeah, absolutely. And I think the private sector is becoming more and more active in sort of the ESG world, generally speaking, and they're now driving action that really, I think, a lot of people have felt was maybe the responsibility solely of governments. So the private sector is becoming more and more concerned. As I mentioned, we all live on the same planet, and while corporations tend to have a bad track record when it comes to certain decisions that they make in the context of the environment, I think the shareholders now at those corporations, shareholders in the private sector, including banking and finance sector, now realizing that we only live, we all live on one planet. Things are getting to a critical stage, and we need to start looking at things on a longer timeline. So, for example, shareholders in banks have been traditionally focused on very short-term returns. So, every quarter, bank needs to post good numbers, and otherwise shareholders are unhappy. They sell the shares. Market capitalization of the bank plummets, which puts pressure on the banks to make very short-term decisions. By their very nature, green projects or investment in green projects have a longer timeline when it comes to returns, and those returns need to be looked at holistically. I think, as Tom alluded to, the returns just can't be measured, strictly speaking, in terms of financial returns this quarter. But if you look at financial returns over a long enough time period, actually the logical decision or logical conclusion that's reached is actually it makes more sense to invest in green projects than it does in others, in non-green projects, for example, in the petrochemical sector, because those green projects will have a longer lifetime, will be more in demand over a certain period, will result in a better impact for the environment, which has better impact generally for for people living in those markets, which creates greater demand, which then creates more sustainable consumption over a longer period of time, which results in better profits or greater profits for everyone. So looking at it as in a sort of holistic manner, in the sense that all of these different things are interlinked, and on a long enough timeline, something that's bad for one particular node of that interlinked chain will be bad for all the players in that chain, means that I think stakeholders are starting to realize that they need to shift away from short-term profit maximization to looking at more long-term considerations. And there is a realization that we do need to address, this. I think there's a growing realization, even in the banking and finance sector, which is, sort of renowned for its short-sightedness and profit maximization, so adhering to the profit maximization motive. Even in that sector, there's just increasing pressure on institutions to behave in a certain manner that's more long-term, that's more ESG friendly. The pressures are different in different jurisdictions, but I think what we are seeing, generally speaking, is a rise in that pressure, and I think that's putting more and more. That's creating greater impetus in the private sector to behave in a particular manner and to create ESG products and to promote them and to buy into them. Does that answer that question?
I think so, yeah. Absolutely. Well, I haven't had a confirmation that it does, but I think it probably did. It's one of those fascinating subjects. Yes, thank you for the answers. Wonderful. I think you're probably right, Najwa. There probably were multiple answers to different questions in there, because it is one of those subjects that's just so interesting. Okay, we have. There don't seem to be any more questions in the chat box at the moment. I'll just give it another minute or so. This is part 2 of 2. So it concludes this session for 2021. But for those of you who are feeling any sense of disappointment that it might be the end, don't worry, we'll try to organise more for the next year. And no doubt we'll be able to come back to some of these themes, especially the green element and how the market's developed. Oh, we've got a question. Sakina, thank you very much. Hello, good sir. This is for you, Elias. May I know, what are the challenges? God, they're asking you some difficult questions today. I love it. What are the challenges to the development of green Sukuk in the market?
Yeah, I think that it depends on the market. So certain jurisdictions just don't have the laws in place that facilitate Sukuk issuances generally. So that acts as an impediment to Sukuk issuances. So there are certain jurisdictions where actually they would like to tap into the Islamic capital markets, in particular for green projects. Again, because I spoke about as I spoke about, there is that alignment between Islamic investors or Sharia compliant investors and green projects, because they can invest in something that makes a return, but that also has a positive social impact. But in certain jurisdictions, in particular, a number of European jurisdictions, there just isn't that framework that facilitates Sukuk issuances. So, for example, if you were to use the Ijara structure that we discussed earlier in certain jurisdictions, it would result in certain tax liabilities or tax risks that are just not going to be acceptable for a obligor looking to raise funds in the capital markets by issuing green Sukuk. So I think those jurisdictions and those markets need, as a starting point, just to change the laws to allow and facilitate Sukuk issuances so that they can be done as easily and on the same level playing field as conventional bond issuances. Now, in other jurisdictions, there are a number of factors that inhibit the projects from just getting off the ground, and we spoke about a couple of those being the regulatory environment, the business environment, ease of doing business, like, corruption is a particular issue in a number of jurisdictions, and a number of international investors cannot participate in the bidding processes in the same way as entities from other jurisdictions. So, for example, a number of UK entities may not bid for particular projects in particular jurisdictions because they know as part of that bidding process, they'll have to entertain, shall we say, certain people involved in that bidding process. And that's prohibited by the laws in the UK. And Tom can speak to that in more detail because he's done quite a lot of work around UK Bribery Act, I think. Is that right?
Yeah.
Yeah. But I won't put you on the spot, Tom. I won't put you on the spot. I was just
anti-bribery.
Anti-bribery.
Yeah.
So I think having some implementing laws in those jurisdictions to facilitate businesses generally, reduce corruption, and improve the ease of doing business would attract investors, in particular international investors, which would mean that those projects are more likely to get off the ground.
I think Elias's other point, or what was touching on it earlier, which is straying way out of legal, and it's almost a political discourse. Young Ping's, she's giving me that look as if to say, "Don't start." But I'll say it briefly. But it's that trade-off between, and there's a lot of stuff out there about this, but sort of rich countries versus developing countries, and the fact that countries need to be able to develop, and so there's that trade-off between how much you can invest in these sorts of projects. So I think that goes to the question of challenges of developing that market. If you're an economy that's trying to grow at a much faster pace, then it may be that you prioritize, other sort of investment, fundraising, and projects over the urgent, but obviously less economically viable, certainly in the short to medium term, green projects, and then it becomes, quite political in that space, which is why you see a lot of the initiatives being driven, in a macro level, being driven at COP26 and amongst the sort of the G7 and so on, because they're the ones who've caused a lot of the problems. So they're the ones that are now trying to fix them, I suppose.
Yeah, absolutely. Actually, that's unfortunately, that's a political discourse is proving that, I should say discord probably, is proving to be a significant inhibitor of the growth of a harmonized and sort of more standardized green Sukuk or green bond sector, because as you say, a number of parties in a particular jurisdiction will accuse certain countries of implementing or seeking to impose these environmental standards on them in the context of having already benefited significantly by polluting the environment and making the whole world worse off for everyone else. So now that they are in a place where they have sufficient financial and intellectual capital to move away from these fossil fuels, they were to then impose those standards on a country that isn't quite there yet, it inhibits the development in that country. which means that that country then effectively that the country's growth is stunted, which then means that there's a social impact as well as a political impact on the world stage, because that country then becomes less powerful and doesn't necessarily achieve certain potentials as quickly as it would have if it was taking the easy route and burning fossil fuels now, as opposed to investing in a 20-year or 30-year or 50-year strategy to develop green energy projects. So that sort of discord, unfortunately, is not particularly helpful. And it would be, I think, incumbent on those developed, rich countries, as you said, Tom, in actually making up now and for some of the damage that they've caused, and effectively helping everyone, I think, using those intellectual and financial resources to help everyone globally, all countries globally, to move towards a greener future. Because ultimately, we do live just on one planet, and I think if we continue going down this particular route, we're all going to suffer some fairly horrendous consequences. I mean, sort of looking at the floods in the UK and the fires in the US over the summers, just some fairly extensive damage, very costly damage being inflicted by these climate change events. So it's not just limited to, it's not just developing countries that are going to suffer. I guess it's everyone.
Okay.
Sorry, I went off tangent there.
No. It's definitely one of those subjects. It's definitely one of those subjects. Okay, there have been no more questions posted in the last 7 minutes. I would encourage.
I think that's a cue that we should wrap up.
Yeah, exactly. I was going to say I'd encourage more discourse, but I think our time is probably up, and I know you guys will all be very busy as well. So, other than saying thank you so much all for your time and being here today, and hopefully that you found it all interesting. It's great to have seen the questions and the engagement, and hopefully we'll be back here soon. Ibrahim, shall I hand back over to you to wrap things up?
Thank you, Mr. Reynolds. Just before we close the Q&A section, since the majority of us here are students, I think a lot of us as students would like to know: is there anything are there any opportunities for students to contribute in Sukuk or Green Sukuk? Before this, this is the last question before we wrap things up. Something to incite all the students here that are watching.
Well, absolutely. I mean, I think that students have a voice, and you're the leaders of the future. You're also the voters of the future. So I think people tend to listen to, or at least they should be listening to, what students are saying, and they should be paying attention to their views. And I think that, I mean, to the extent that you feel strongly enough about it, and to the extent that it's an area that you're passionate about, I think contributing to the sort of the growing body of commentary around Green Sukuk, contributing to the growing number of events around promoting the discussion of Green Sukuk and what can be done to facilitate the issuance of Green Sukuk, I think is very important. So, investing your time in that and lending this sort of segment your voice, I think would be extremely helpful and very powerful. And obviously that opens the doors to a number of other opportunities, which I think could potentially be of great benefit to that particular student. Does that answer the question, or was there something more specific?
No, I'm pretty sure that was the answer, that the best answer that we could receive at this point in time, because it's just, the whole Sukuk thing is kind of new to us.
Do you still do project paper in your third year?
Yes, we do.
Well, we'll be very interested to see a mini thesis or a research paper on ESG then.
Yeah,
and
absolutely.
Yeah.
Absolutely.
All right, with that final question, I guess that's the end of our session here today. Before we completely wrap up, I would like to request all in attendance to activate your cameras so that we can have a group photo together.
This is where we find out who's walked away from their computers, right?
Who knows, some of them might actually be shy.
No, I know, I'm teasing.
they might be shy because we have two very handsome speakers here today.
Of course. Oh, I don't think that's true. That's the first time anyone's told me that. Or maybe you're talking about Yuen Ping and Elias anyway.
Oh, so a very backhanded compliment to Yuen Ping, calling her a handsome lady.
I was great affection.
We'll give them another minute to activate their cameras and all. To those who can activate your cameras, please do activate your cameras. Please don't be shy.
Nice to see you all.
Yeah, it's great. Yeah, it's often difficult doing some of these Zoom presentations because you don't get to see even if you had your cameras on, I wouldn't have been able to see your faces because of the way my Zoom app seems to be working. So it's really good to see everyone. Hopefully the next one we do will be in person when things allow it. So it looks like we are moving in that direction. So very
Zoom
much
is easier. Certainly for when I'm doing the majority of the speaking, where Zoom is my preference, is that when it's an after lunch slot like this one is, if anyone falls asleep, I don't know virtually because I can't see them. Whereas in a room, I can see them sleeping. So I prefer this in some ways.
Then to everyone who has their camera open, okay, please smile pretty for the camera. 1, 2, 3. 1, 2, 3. Okay, everyone, please tell yourselves 1, 2, 3. 1, 2, 3. All right. Okay. With that, we wrap up today's session. We would like to say once again to Mr. Tom Reynolds and Mr. Elias Mubarak for being here today and giving us a very inside look into the world of Islamic financing. We would also like to thank our alumni, Miss Yuen Ping, for being with us here today. With that ends the session of Let's Talk. With that, thank you.
My IT cut out, or Ibrahim's IT cut out there, possibly. There you go, you're back.
Okay. Did my closing get cut off?
Yeah.
Only the last 10 seconds. I assume it, no worries at all. At least it happened then and not halfway in or at the start.
So, should I repeat myself?
No, it's fine. Have a great afternoon, everyone. Thank you again for your time. Unless you were saying nice things. It depends if you're saying nice things or not nice things.
But all the time.
Have a great afternoon.
We will assume that it was nice things. Thank you very much, everyone.
We'll keep in touch. Take care.
Thank you, Mr. Tom, and also thank you to Mr. Elias. And also Miss Yuen Ping. Thank you very much.
No problem.
Thank you all so much.